Attorney Troupas, are you prepared for rebuttal?
Yes, sir.
Please go.
Your Honor,
Attorney Troupas, we left off with Democracy in the Park, what Justice Ziegler had asked about. So that the event was announced 4 weeks before the first Democracy in the Park took place. Did the president file an injunction to prevent that event from happening because it was going to be an unlawful voting procedure that you're alleging now?
no.
And did he then, there was another event, so that was back in September. That was August when it was announced. September 26th was the first one. Did he file an injunction before the second event on October 3rd?
No,
And did he ever file an injunction?
not that I'm aware of.
He just chooses to challenge it now after he lost the election, correct?
I don't think it was a conscious choice to not do it before or not do it after. It was an obligation under the statutes, 901 sub 11, that merges all of the claims of the Trump campaign into a recount statute. As we advised the president, and as is, I think, the only view in the law of the state of Wisconsin, all items merge into the recount process. And of course, the reasons for that are that justiciable controversies are obviously posed there. We have a number of cases, they're cited in the briefs, where many issues are raised during recount proceedings. For example, illegal voters or improper voters. And there are constantly, they use a drawdown process and it's mandatory.
Again, Mr. Troupas, one illegal voter, one person who engaged in fraud at Democracy in the Park. I mean, isn't it true that the reason that your client, Donald Trump, did not file this action until after the election is because it wouldn't make any sense to do it if he had won? But now afterwards, he wants to go back and complain about things that he could have complained about 2 weeks before the election, such as Democracy in the Park, the forms that have been used for 10 years, all of these things he had the opportunity to complain about before the election, but he chose not to. And now after the election, he wants to disenfranchise 227,000 voters.
We do not want to disenfranchise voters. We want the law enforced. And your question implies something that I think needs to be addressed, which is that if this court were to hold that Donald Trump or any other candidate must speculate on what might happen in an election under some law that might or might be enforced by an agency guideline that might or might not be followed, then we are headed in a very dangerous direction.
Mr. Troupas, no one is saying that he had to speculate. All these things were in existence before. I want to ask you about something you talked about before, and you were talking about absentee ballot, and particularly statute 6.84 sub 1 and sub 2.